The African Court on Human and People's Rights is now in session. In the matter between Human Rights First and the State of Rwanda, the Honorable Judge, Lady Justice Imani Dodd Abud, presiding.
This is a matter between Human Rights First and the State of Rwanda. And may I call upon the applicant side to start the proceedings. And you have been accorded 15 minutes in each oralist. For both, I think you are in the applicant, you're 4. And it will all depend on how you have organized yourself to make sure that you don't go beyond the 30 minutes which have been given to you according to the court procedure. We have been given 30 minutes, and I don't know whether 30 minutes to be divided equally for the 2 pairs among yourselves, or it depends on the way you have organized yourself, but you're not supposed to go beyond 30 minutes. This is as well applicable to the respondents. You're also given 30 minutes, and it is upon you to organize yourself. How much minutes are you going to spend in each team? There are some changes on the time allocation, that each team has been allocated 60 minutes. So you have to organize yourself within that time limit. And there will be a rebuttal on the applicant. You will have only 3 minutes. So please observe time, and we hope you'll be confined within, you comply with what we have accorded you. And now, let us start with the applicant side.
Madam Chair, esteemed guarantor of the human dignity at African continental level, when the fire burns the forests, that the animal runs to the river. Today, the lawyers of the human rights are running to the saving and protecting river in the court in order to demonstrate to you how Rwanda has sovereignly engaged itself through different conventional instruments.
Des droits de l'homme a par la suite violé les droits de l'homme, d'abord en retirant sa déclaration facultative d'acceptation de la compétence de votre juridiction. Ensuite, en privant la tribu Omia de ses droits vitaux en expropriant leurs terres ancestrales. Puis, en renversant et en détenant le président élu démocratiquement par le peuple du Rwanda. Et enfin, en portant atteinte tragiquement et monstrueusement aux droits vitaux de M. Ditan, en accédant non seulement à ses données à caractère personnel, et puis en le condamnant. Honorables juges, mais avant de scruter ce summum de l'injustice, et pour emporter votre...
order to bring this conviction to your knowledge, and with reference to Article 49, and order to try to eliminate the necessary issues pertaining to the your jurisdiction and the admissibility of your court. Before we give the floor to our colleagues, we should tell you there has been a decline of the state that is abandoning its citizens to the violation of their dignity and their rights. With the current jurisdiction, there have been violations at four layers: personal, material, territorial, and temporal, and that are comprised in this matter. The material jurisdiction has been met at Article 3, paragraph 1 of the Ouagadougou Protocol, and notably in the Alex Toma versus Tanzania, it has been
est remplie dès lors que la
jurisdiction has been met as long as this report relates to the human rights, and this has been.
Or, en l'espèce, nous invoquons la violation d'instruments de droits de l'homme effectivement ratifiés par Rantania comme établi au paragraphe 3 du rapport factuel. En outre,
the people of the state of Retania and the African Charter for People and Human Rights, these two pacts and the convention of the ILO for labor rights, it's obvious that our application is.
Excusez-moi, maître, en quoi la convention de l'OIT est une convention de droits de l'homme?
Madame la Présidente, selon votre cours, pour savoir si une convention est une convention relative aux droits de l'homme, votre cours dans l'affaire APDS contre Côte d'Ivoire a défini l'instrument pertinent aux droits de l'homme comme tout instrument qui consacre des droits de l'homme au profit des individus ou des obligations à l'égard des États pour la jouissance de ces droits. Or, la Convention de l'OIT sur l'âge minimum de travail vise à protéger les droits de l'enfant tels que consacrés dans divers instruments des droits de l'homme. Il va de soi que la Convention de l'OIT sur l'âge minimum de travail soit, au sens de votre jurisprudence, définie comme un instrument pertinent aux droits de l'homme. Honorable juge, nous avons précédemment démontré que votre juridiction avait la compétence matérielle de connaître de la présente affaire. Sur le volet rationnel personnel de votre compétence, elle s'analyse de jurisprudence constante et abondante, notamment dans l'affaire Kounassi 7 contre Gabon au paragraphe 9, à l'aune des articles 5, alinéa 3 et 34, alinéa 6 du protocole de Ouagadougou. Tandis que le défendeur doit avoir fait la déclaration facultative d'acceptation de la compétence de votre juridiction, le demandeur, lorsqu'il est une ONG, doit avoir le statut d'observateur auprès de la Commission africaine des droits de l'homme et des peuples. Or, au paragraphe 3, lettre E du rapport factuel, il est clairement indiqué que Rantania est parti au protocole de Ouagadougou depuis 2015 et a déposé sa déclaration facultative d'acceptation de la compétence de votre juridiction le 2 août.
Jurisdiction from 2017, yet the paragraph 7 states that that UNNGO abides by the African Charter of Human Rights and People's Rights. If the applicants supports the incompetence of your court because Rwanda withdrew from this protocol, we will call upon your authority to remind them that this issue has been settled by your court in consolidated case law. First of all, in the case of Ingabire against versus Rwanda, there was a lot of accurate details as highlighted in paragraph 7, and versus Benin, paragraph 7, and very recently in the case of Morona in 2017. So So the declaration made has no incidence either on the dependent matters or on the case to submit to your court before the withdrawal of this case. In this case, the NGO has submitted its application in your court 6 days after the withdrawal of the Rwanda declaration, the declaration that Rwanda had signed. So it's obvious that your personal competence is demanded to intervene. Following your constant case law, it was highlighted that paragraph 77 that it suffices that the critical facts occur on the defendant's territory, and you can see that the background of this matter took place in Rwanda. It's important that your jurisdiction is clearly has the clear authority to rule, and this can be appreciated in according to paragraph 38 in the ruling between Johnson versus Tanzania by the defendant country. But the fact of violation that is presumed is later posterior to the withdrawal of Rwanda from the protocol, because in 2017, as stated in paragraph 3 of the factual letter, while all the violations occurred in between 2022 and 2024, that shows that your competence has the authority to rule out. So the strictness of our reasoning calls upon your competence and the demonstration of the admissibility and undeniable of our application. Reference on Article 6 on the Ouagadougou Protocol, Article 56 of the Charter and the internal regulation of your court declines the admissibility of the requests by the contestants in the current application. Nonetheless, in order to ease with the elements of the defense, we will underscore the prior exhaustion of remedies as planned at Article 56 of the Charter. That means the ruling out on matters like this according to the regulation of the United Nations. So the request must be introduced after exhausting internal remedies, domestic remedies, unless there is abnormality. Nonetheless, in the decree of the Benin Article 88, it was that internal remedy only concern the effective application. So for the case of Mr. Deten, the the remedy was not available because he was convicted to a penalty that could not allow him to appear to the court. Could you come back to your question? I didn't get the question clearly.
On the matter of Mr. Deten, you could have rendered it as a constitutional matter before the Supreme Court, but you didn't. He was convicted lawfully by the High Court. It was upheld by the Court of Appeal. And if you had issues with that, you could have gone to the Supreme Court questioning the act itself, whether it was constitutional. You could have done that. I'm saying.
Merci bien, honorable.
Thank you very much, Honorable. Following paragraph 2 on the factual report, it was highlighted that the Supreme Court is only competent in criminal cases, not in violations of people who were convicted to a penalty higher than 5 years. Yet Mr. Ditan, at paragraph 18 of the factual report, was convicted to a penalty of 3 years, for 3 years sentence. So we had not to go to the Supreme Court because it was not in the competence of the Supreme Court. As for Mr. Okello, his remedy was effective because it was clearly indicated that the judicial system was run by actors that were the authors of his overthrow. And for the situation for the case of working children, the remedy. Est-ce que vous
Faith in the judiciary of Rwanda?
There is problem in interpretation, Honorable Judge. So can you assist?
Yes, yes. On vous demande si vous n'avez vraiment aucune confiance dans le système judiciaire de l'État défendeur.
Honorable juge, tel que les...
Honorable Judge, as events occurred in Rwanda along 2022, we can doubt on the efficacy of the judicial system because the judicial system is run by private enterprises to the point that ordinary citizens cannot trust the system.
As an applicant, have taken the matter to the High Court, and you have also gone to the Court of Appeal. If you didn't believe in the functioning of the judiciary, why did you go there in the first place?
Effectivement, honorable.
Effectively, it's just because we first of all went to the higher court and to the Court of Appeal, and with regard to the ruling that was done, we were convinced that the Rwanda judicial system was not efficient and effective and efficient. And for the second requirement at Article 57 of the Charter, it will be clear to your court that we are in a situation of a ruling we need a ruling of international conventions when the identity of the party and the application and which is not the case in the present matter because of the international labor office organization were contacted and the matter was brought to your court by the NGO. Therefore, we ask you to consider our submission. Thank you.
You're done. Thank you.
President Judge, Your Excellencies, my name is Imelda Okingo, Second Counsel for the Applicants, Human Rights First. Your Excellencies, I will be taking 12 minutes to canvass Issue A on the withdrawal of the Article 34.6 declaration. If there are questions from the bench, I will beg to proceed. Much obliged. Your Excellencies, the question before this honorable court revolves around a state that has and continues to deliberately fail to uphold its tripartite obligations to its citizens, that being the obligation to respect, protect, and promote the rights of its citizens. That failure has seen the violations of the right to property of the Omia people. It has further seen the violations of the rights of the child laborers in the state of Rwanda. It has further seen the overthrowing and detainment of the democratically elected president of the state of Rwanda. And it has further seen the violations of the right to freedom of expression and the right to privacy of the citizens of Rwanda. It is on this aegis that the applicants humbly approached this honorable court to show it in its preceding arguments that the violations did indeed occur and pray that this court redresses the same. Your Excellencies, before proceeding to the first issue, I would like to buttress an argument from a question raised by His Excellency on the constitutionality of the legislations with regards to Mr. Ditan's issue. Your Excellencies, this court in the case of Wilfred Onyango Nganyi versus Tanzania, in paragraph 95 of its judgment, stated that extraordinary judicial remedies need not be exhausted. From a reading of paragraph 2, Challenging the constitutional compatibility of a legislation is deemed an extraordinary legal remedy, and as such, the applicants needed not bring the matter before the Supreme
What will
Court.
be your definition of extraordinary legal remedy?
Much obliged, Your Excellencies. As of now, pardon the applicants, Your Excellencies, for excuse the limitations of memory, the applicant does not have a specific definition. However,
What do you perceive to be?
an extraordinary legal remedy, one that the applicant cannot pursue without impediment, Your Excellencies. If a remedy can be pursued well without affecting the rights of the applicant, then that can be considered a remedy that can be pursued.
But I would suppose every legal remedy comes with such challenges.
Pardon, Your Excellencies?
I would suppose that every legal remedy comes with the challenges you are positing.
Yes, Your
So
Excellencies.
it doesn't necessarily make them extraordinary.
Much obliged, Your Excellencies. However, from the reading of the judgment in Wilfred Onyango and the reading of the fact pattern, the same wordings have been used, an extraordinary legal remedy. And as such, Your Excellencies, the applicants needed not pursue it.
Just, you mentioned, are you suggesting that this recourse to the Supreme Court would only on the basis of challenging legislation? Is it not possible from what has been contained and provided in terms of the jurisdiction of the Supreme Court that you can approach the Supreme Court not necessarily on the basis of constitutionality, but on the basis of bringing a matter from the Court of Appeal?
Much obliged, Your Excellencies, and if I got you correctly, yes, an applicant can approach the Supreme Court in other instances, not necessarily the issue of the constitutional compatibility of legislations. If I have not got you clearly, kindly rephrase.
So why did you make reference only to the question of constitutionality?
Much obliged. I made reference to that to buttress the response given by my co-counsel in respect to the question raised by His Excellency. If that suffices. Moving on to my main issue, Your Excellencies, on the withdrawal of Article 34.6 declaration, it is the applicant's submission, Your Excellencies, that in appreciation of the well-founded principle of state sovereignty, from which the optional nature and the unilateral character of declarations emanates, the applicants admit that the withdrawal is valid. However, Your Excellencies, the crux of the applicant's submission is that this withdrawal undermines the rights of Rwandanians with specifics to the right to be heard as enshrined under Article 7.1 of the Charter. Your Excellencies, the primary purpose of a human rights court is to protect citizens against the state, its agencies, and third parties by granting them justice. This purpose is realized by Article 7.1 of the Charter that allows citizens to approach this honorable court in cases where there are violations. The realization, or rather in giving effect to Article 7.1 of the Charter, Article 34.6 of the Declaration plays a key purpose, in that it allows NGOs and individuals to directly access this court in instances where states have violated their rights or allegedly violated their rights.
Counsel, are you suggesting that withdrawing from Article 34.6 would be a negation of Article 7 of the Charter?
Much obliged, indeed, the applicants submit that.
If that is the case, for citizens in states that haven't declared Article 34.6, are you saying that they don't have access and their right under Article 7 is not protected? Is that what you are suggesting?
No, Your Excellencies. We do note that the scope of the application of the rights under Article 7 can be given effect in cases where the domestic judicial remedies are empowered. However, in this instance,
I'm saying you have the state of Ratina that
Yes.
declared, and you have another member state of the African Union that hasn't declared
Yes.
34.6. Withdrawal of 34.6, you are suggesting, negates Article 7.
yes, Your Excellency.
But there is no declaration of Article 7 here in this state. Are you therefore saying that in this state Article 7 of the rights is being violated?
No, Your Excellencies, and in responding to that, the applicants do admit that indeed Article 7 has a wide application in that where domestic judicial remedies of a state are empowered, then it can be said to be protected. However, from the first counsel of the applicant's submission...
So, there is a substantive question here. The substantive question is the protection of Article 7 contingent on Article 34.6?
Much obliged, Your Excellencies. With regards to the regional judicial system, it is contingent on Article 34.6.
So in countries where Article 34.6 is not declared, Article 7 is violated?
No, Your Excellencies. And to answer your question, allow me proceed. Your Excellencies, yes...
If you say it is contingent on, then the absence of one leads to the violation of the other. That's what I understand by contingency.
We do note your concern, Your Excellencies. However, in a country with an empowered judicial system, then the rights of the citizens...
We are talking about the jurisdiction of the court. We are talking about the jurisdiction of the court, this court.
Yes.
Not what happens at the national level. That is why I wanted you to be clear on your logic and reasoning.
Much obliged, Your Excellencies. And to further try to buttress our response to that question, the 2063 Agenda of the African Union encourages states to recognize the court and its protective mandate over human rights, especially where domestic remedies in a state are unavailable, ineffective, and insufficient. In this instance, the domestic remedies in the state of Rwanda are unavailable, insufficient, and ineffective, and as such, Article 7.1 of the Charter is violated in that regard, and the citizens need a recourse to a human rights body or tribunal that can remedy the same. That is why they approach this honorable court. Your Excellencies, we will proceed.
So you are saying that 4 countries that do not have Article 34.6 declaration, there is no remedy before this court?
Kindly rephrase for purposes of clarity.
Article 34.6.
Yes.
States parties to the protocol
Yes.
that didn't declare Article 34.6, direct access. Are you suggesting that they can't invoke Article 7 of the Charter?
They can invoke Article 7 of the Charter,
Thank you.
Your Excellencies. Much obliged. Your Excellencies, proceeding on to the submissions, a withdrawal of that declaration violates this right because it violates the principle of non-regression. Your Excellencies, this court in the case of Ajavon versus Benin of 2020 stated that the principle of non-regression is a corollary and extension of progressive realization of a right. And progressive realization requires states to take active steps in the realization of a right. Any backward step or any retrogressive step when a state has realized or actively tried to realize a right is then a violation of the principle of non-regression. And as such, Your Excellencies, the applicants reiterate that the withdrawal of Article 34.6 declaration by the state of Rwanda is a violation of the Charter because it violates the right of the citizen to access this court and by extension, the right of the citizens to get an effective remedy.
You seem to be suggesting that a state should not and cannot withdraw.
No, Your Excellency, that is not the position of the applicants. Your Excellency...
Just saying that's what you seem to be doing here.
Indeed, Your Excellency, it might seem so. However, the applicants appreciate the internationally founded principle of state sovereignty. And as such, we do admit that states can indeed withdraw. However, we would like this honorable court to appreciate or take into consideration the effects of the said withdrawal. The effect herein being that the withdrawal violates the rights of citizens to be heard before this honorable court, and by extension, the right to get effective remedy.
It's mixing withdrawal from Article 34.6 from withdrawal from the court protocol.
Much
The
obliged.
two are separate things. As long as Rwanda is a state party to the court protocol, then the Rwanda remains obliged
Much obliged, Your Excellency. And in response to your question, Article 34.6 declaration is the article in the protocol. And a reading of Article 5.3 of the protocol vis-a-vis Article 34.6 of the declaration provides that NGOs and individuals can directly come before this honorable court only if the state against which an application has been filed has deposited the declaration. And as such, Your Excellencies...
So the only deprivation is direct access?
Yes, Your Excellencies.
That is it?
Yes, Your Excellencies.
Access remains?
Yes, Your Excellencies. That
Thank
is
you.
access via the African Commission. However, Your Excellencies, we would much obliged, sorry I did not notice the time, I would request 30 seconds to sum up.
1 minute.
Much
Granted.
obliged. Your Excellencies, we do know that there's an alternative. However, we would like this court to take into consideration within 10 years of complementarity via the African Commission and this honorable court, only 3 matters have been forwarded before this honorable court. And as such, Your Excellencies, the applicants submit that that alternative is not viable as at now. Your Excellencies, much obliged. Your Excellencies, the applicants reiterate that the withdrawal of the Article 34.6 declaration is indeed a violation of the rights of Rwandans, and would like the court to take this into consideration while they write their judgments. With that, I will cede floor to the co-counsel.
Okay, just one question. Can you justify your argument that the access or the route through the commission, the Human Rights Commission, the Banjul Commission is not viable just because they have transferred only 3 cases? Because when you take the matter through the Human Rights Commission, it's upon them to see whether that matter should be taken to the court or not. So the viability of Banjul Commission, what are the criteria to assess the viability? Is that the transferring of the cases, or how it is effective in its performance?
Much obliged, Your Excellencies, and indeed those 2 measures can be taken into consideration when looking at viability. First, the number of cases referred before this honorable court being only 3. And secondly, Your Excellencies, when it comes to the effectiveness of the decisions given by the African Commission, we would like this court to take into consideration Article 45(1)(a) of the Charter, which states that, Your Excellencies, the African Commission can only give recommendations to governments, while this court can give binding judgments as pronounced in Rule 72 of the rules of this court.
Can you enlighten us? While the Charter provides for that, is there any instance in which, on record, a state party refused to follow the decision of the African Commission because it's a recommendation? Is there any instance?
Much obliged. Applicant is not, the counsel for the applicant is not aware of any instance as of now. However, we will look into that after the matter, if that suffices, Your Excellency.
Thank you. Your time out, but just a matter of something to think about. Judging the Banjul Commission on the basis of the number of cases transferring to the court, it's not something which is very valid, because you haven't been, you were supposed as applicant to send your case, to file your case through the African Commission with intent that that matter should reach the African court and have the binding decision. So that is a procedural thing.
Yes, Your Excellency.
Okay.
Thank you for your guidance, and the applicants will take that into consideration.
Much obliged, Your Excellencies. I am third counsel for the applicant dealing with substantive issue B. Your Excellencies, the applicants do not approach this court to be granted rights that have not already been guaranteed under the African Charter and other international human rights treaties. Rather, Your Excellencies, we pray for a recognition of already guaranteed rights. The crux of this issue, Your Excellencies, revolves around two sets of people. The first are the Omia people, and secondly, the child laborers. On the first, the applicant shall prefer one limb of argument, that the Omia people are an indigenous community and that their right to property was violated. With regards to the issue of indigenous communities, Your Excellencies, this very court has had an opportunity to
Counsel,
discuss.
what makes them indigenous?
Much obliged, Your Excellency. To answer your question, there is a criteria that must be satisfied for a community to be deemed indigenous. And this very court, in the case of African Commission versus Kenya, upheld the criterion to determine whether a community is indigenous or not. And this, Your Excellencies, is further buttressed under Article 1B of the ILO Indigenous and Tribal Peoples Convention. That includes, Your Excellencies, the occupation of a specific territory, the voluntary preservation of a cultural distinctiveness, an experience of marginalization, subjugation, or dispossession, and additionally, self-identification as a distinct collective. Your Excellencies, with regards to the Omia people, we shall rely on the facts under paragraph 6. Indeed,
Counsel, why does the issue of indigeneity matter in this instance? Why does it legally arise?
much obliged, Your Excellency. To answer your question, the issue of indigenous communities is integral in this case, in that, Your Excellencies, the Omia people have experienced dispossession of their land, and they have a certain link to that land, in that their ancestors occupied this land for over 100 years. The issue of indigenous communities is integral because the indigenous communities are offered a quote-unquote special kind of protection. That is not to say, Your Excellencies, that they are a special set or category from other peoples, Your Excellencies, but rather the term indigenous is intended to create, is not intended to create a special class of citizens, but rather it is to address the historical and present day inequalities with regards to the other populations.
Are you suggesting that the rights allegedly violated in relation to the Omia people couldn't be fully and exhaustively vindicated without reference to them being indigenous?
Much obliged, Your Excellency. That is not applicant's position. Indeed, the rights of the Omia people could be actually acceded to, even if they were not granted the indigenous status. Your Excellencies, the Charter applies indiscriminately to all human beings and persons, irregardless of their stature.
And therefore, the question of indigeneity is not a substantial issue that we should really bother about. We can just proceed to look at the substance of the allegation on the rights.
Much obliged. Applicant shall address the issue of violation of the right to property. Indeed, we are aware that this right has been codified in Article 14 of the Charter. Applicant has also had an opportunity to review respondent's memorial, and they will indeed come before this court.
Excusez-moi, maître. Est-ce que la charte parle de propriété communautaire, de propriété des communautés autochtones, telle qu'adoptée en 1981? Et vous avez parlé tout à l'heure, si je peux prolonger ma question, du critère de la self-identification.
Self-identification of indigenous people. Why, in this case, the issue? Are you getting interpretation, please? Are you getting it? Yes.
Indeed, the Charter does not specifically talk about indigenous communities. The body of laws that talks about indigenous communities is the ILO Convention on Tribal and Indigenous Communities that has been ratified by the respondent states. If that suffices, Your Excellency, I shall proceed.
Je crois que la question qui continue par là.
I think the question that is brought forward here is to know in which regard the ILO law constitutes a violation of the human rights.
Much obliged, Your Excellency. If applicant has gotten your question correct, the ILO Convention is a body of law that has been ratified by the respondent state, and Your Excellencies, it forms part of the laws of Rwanda, in that, Your Excellencies, it is part of the laws that have been ratified. With regards to the issue of the indigenous communities, Your Excellencies, the applicant's position was to buttress the violation of the right to property. If that suffices, Your Excellencies, the applicant shall proceed with the issue. Indeed,
Haven't they been offered and given indeed modern living quarters?
yes, Your Excellencies, the Omia people have been compensated. But the question before this court is not the issue of compensation in and of itself. The issue is, was it adequate compensation? The applicant submit that it was not adequate compensation. Compensation, Your Excellencies, is deemed adequate if it takes into consideration the special characteristics of the people in question. Reading of the facts under paragraph 6 states that the Omia people are a pastoralist community, and giving them a domiciled government state-funded housing units would be a violation of their right to participate as a pastoralist. In that, Your Excellencies, they move from one place to another, and their survival relies on an unhindered access to adequate grazing and farmland. Your Excellencies, the second issue that is raised before this court with regards to the right to property is consultation. The facts do indeed state that the Omia people were evicted from their ancestral lands without consultation. And indeed, the African Commission in the Endorois case held that the crux of a limitation of the right to property must in fact take into consideration consultation and adequate compensation. With that, Your Excellencies, we submit that...
You do realize that a good number of the Omia have accepted the modern living quarters.
Yes, Your Excellencies.
So this issue of they being pastoralists really doesn't hold water with them?
Much obliged. And in response to your question, Your Excellencies, we invoke the Endorois case before the African Commission under paragraph 231. The African Commission was of the view that though some members of the community had accepted the limited monetary compensation that had been offered by the government of Kenya, that could not mean that they accepted it as full compensation, or indeed they accepted the loss of their land.
Maître, est-ce qu'on ne peut pas aussi prendre cet argument?
Lawyer, can we take that argument that goes in the interest of the general sense and the protection of the people's rights? Because we understand that the Omia district offered modern quarters to the Omia people. We realize here that not all the population of the Omia, but only 1/3 of the population were already settled in towns. Isn't it a sort of development to move these people from rural areas to urban areas? It's a sort of development for these people.
As Your Excellency, and applicant has noted your concern. However, Your Excellencies, in reference to the Endorois case, there were 3 safeguards that were noted by the African Commission. Your Excellencies, indeed, we do indeed note that the rights to property could be limited in instances of public need or the greater interest of the community. However, this threshold is in fact stringent in favor of such a community. It requires the 2 main things that I had stated. That was consultation and adequate compensation. But Your Excellency, one of the safeguards given by the African Commission is effective participation of the concerned people regularly and before any exploitation or exploration or development done within their territory. Your Excellencies, this was not done by the respondent states. I shall now proceed to address the issue of the children. Your Excellencies, we prefer one limb of argument, that the respondent state has failed in its duty to protect the children from violations occurring within its territory. And the violation in question, Your Excellencies, is the right to be free from economic exploitation and from work that is likely to be hazardous. What then is hazardous labor? This has been defined under Article 3D of the ILO Worst Forms of Child Labor. And hazardous work is work which by its nature or the circumstances in which it is done is likely to expose children to a potential harm of their safety, health, or morals. Reading of the facts under paragraph 7, Your Excellencies, states that children aged 15 to 18 years have been employed in mining activities. They work as diggers, washers, with inadequate safety equipment and in appalling safety conditions. Further, Your Excellencies, it is stated that children were poorly housed, poorly fed, unable to provide for their families, and most importantly, 10 of them had died due to poor working conditions. Your Excellencies, the state in question, the respondent state of Rwanda, has a positive duty to ensure that violations do not occur within its territory. And indeed, the applicant notes that the violation in question is with regards to the mining concessions signed with MD Limited.
Maître, la question que vous posez à la Cour, peut-être vous pouvez la préciser davantage.
You be precise very much with regard to the question you have submitted to the court. Are you saying the children were working in tough conditions, or were they submitted to work while they shouldn't be assigned to that type of tasks?
Much obliged, Your Excellency. Indeed, applicant has noted your concern. The convention, Your Excellencies, on the ILO Minimum Age Convention, as well as the ILO Worst Forms of Child Labor, do in fact envision a situation where children can work. The contention that the applicant is making, Your Excellencies, is that these children were working in appalling safety conditions and with inadequate equipment.
Excusez-moi, maître, mais en quoi...
I'm sorry, lawyer. In what? How can the bad working conditions can be imputed to the state? In which way? In which regard? How do you attribute the tough working conditions be attributed to the state?
Excellency. Indeed, the African Commission in the case of Serak versus Nigeria, under paragraph 57 of the judgment, noted that governments have a duty to protect their citizens not only through legislation, but also by protecting them from damaging acts by private persons or groups. Therefore, Your Excellencies, since the state of Rwanda signed mining concessions with MD Limited, they are therefore responsible for any action that may be done by
Are the
MD
children
Limited.
employed by MD Limited?
Much obliged, Your Excellency. Indeed, the children are not directly employed by MD Limited. The reading...
They are indirectly employed by MD Limited?
Much obliged, Your Excellency. Allow me to clarify. The facts under paragraph 7 states that at least 2,000 children were employed in mining activities, but they were not directly employed by MD Limited. Some of them were linked to contractors who were working for MD Limited. Your Excellencies, seeing as my time is up, allow me to sum up in French. Honorable
judges, the end of our...
Hello, Council. Have you been granted the extension of time or leave to proceed?
Much obliged, Your Excellency, and Council would like to humbly ask this court and seek your indulgence with 30 seconds to conclude.
Okay, 1 minute.
Much obliged, Your Excellency. Honorable Judge.
Honorable Judge, at the end of our advocacy, our president, could you recognize the violation of the Omia peoples and the working children? Right now, I'm going to give the floor to lawyer Idrissa to demonstrate the next part of the violations committed.
Council, did you learn the French today?
Madam Chair, Honorable Judge of the African Court of Human Rights and People's Rights, regarding these violations, we really insist that the court itself was that the detention of Mr. Okello affects his right to liberty. The overthrow, the coup itself, was a violation of Article 2 of Paragraph 4 of the African Charter for Democracy.
Council, it was a successful coup. The general is in power.
Honorable Juge, auriez-vous l'obligation de reprendre votre question?
Could you repeat your question, Honorable?
I'm saying it is a successful coup. The general is in power. He is the head of state of Rwanda.
Okay. Certes, le coup d'État est réussi.
Sure, it was successful and the generals are in power, but what is bringing us before your court is not the continuity of their government and the procedure that was followed by this government to gain power constitutes a human rights violation. This is what we are bringing to this court. We were saying that the overthrow is a violation of Article 2, Paragraph 4 of the African Charter for Democracy and Governments that was adopted in 30th of January in Ethiopia, that is against anti-constitutional change of the government. On the other hand, this coup is a violation of the citizens for the free participation in the affairs and matters of their country and for their free determination of their political status, respectively. That is enshrined in Article 20, Paragraph 1 of the African Charter of People's and Human Rights and People's Rights. In this commission, it has been clear in the matter in the case of Jawara versus Gambia, when it underscores that paragraph 73 that the overthrow that was operated by the military was a flagrant, a serious violation of the citizens of the Gambia. At the end of paragraph 14 of the factual, General Mahdi, together with other army generals, they overthrew President Okello, who was democratically elected at a great majority at 63%. And it's obvious that there was a clear violation of the Rwandanian rights to have their elect and determine to elect their representatives and for their political determination. As regard the detaining of Mr. Ekol and the violation of his liberty rights, as it is stipulated in Chapter 9, Paragraph 1, constitutes a violation of his political rights. In Fine verses Chapter 2.9.1 in the above mentioned part, in line with the ruling of your court in the case of Anissa versus Tanzania, paragraph 3, this can only limited unless it's the reason, the motives are legal and clear and they are compatible with the procedural, the procedures. Paragraph 14 of the factual report leads us to say that the detention of Mr. Okello took 2 stages. In first stage, that's the first 30 days from 19 January to 18 February 2003, he's been detained secretly without following the stipulations of the legal procedures. His detention from 18 February 2023, from the time he was detained, all the time in violation of his freedom of liberty, even though the Ministry of State has still the possibility to have allowed him to have access to his family and lawyers. If the defense is alluding to the return to public order to justify his detention, they wouldn't, skip up your watchful eye on the violation that has been done. He continued being detained, although he had access to his family and his lawyers. His detention was still illegal and a violation of his rights, and so we're appealing for the recognition of the rights of Mr. Okello. And in order to end with the last block, that's the detainees violation. The violation of detainees' rights as stipulated in Article 9 on civil rights and Article 9, Paragraph 2 of the African Charter was violated. At the end of Paragraph 27 of the African Charter above, and the case law in your court, in the case of Ajavo versus Benin at Article 79, against Moot.
Excusez-moi, maître, il y a une multitude d'affaires Ajavo contre Bénin devant la Cour.
Of cases between Ajavo versus Benin, you didn't precise the year and the precise date of the case that is alluded to. We are talking about 4 and D in 2020. We were saying that your case law of your court highlights the conditions on Article 3, legality, the proportionality, and at the end of paragraph 15 of the factual report, the government instructed if the defense is flagging Article 32 of the Rwandania, Article 30, to remove this article because this provision is arbitrary and not in compliance with Article 17, Paragraph 1.
Maître, je vous interromps à nouveau. Toutes les
Interrupting you again, all the aftermaths, the negative consequences that you are talking about are consequences of the coup d'etat. Isn't this coup d'etat a political issue, and is it stipulated on the governance and peace and security? Can't they deal with this? Is this really a political or a juridical matter?
Cette affaire est juridique.
Is juridical, is legal. Why? Because we demonstrated above that there have been violation of human rights, and you are competent to know about these violations. These rights derive from also the African Charter on Democracy, Elections and Good Governance, that you recognize that this is a pertinent instrument for human rights, and as Maitre Suma read it at paragraph 57, that this is enshrined immediately to...
Ce n'est pas du tout je ne remets pas en cause
Not
l'applicabilité.
really doubting the applicability of the Charter on Good Governance, but adversely, I'd like pointing out that there is Article 24 of this Charter that recognizes the Peace and Security Council precise functions in the case of a coup d'etat. In this line, isn't it that the Commission of the Council of the Peace and Security that should have taken this matter within? This is an infringement of the political rights. You can read the Article 24 on governance. If Article 24
Demande au Conseil de sécurité de prendre ses responsabilités.
Des responsabilités. Demands Security Council to. But nonetheless, they couldn't escape your court. They couldn't, escape your court because it's still a violation. Any public disorder that occurs in a country can be put on the shoulders of the state. Can you
cite a legal authority to back your argument?
Parce que nous citons.
Here we are citing the draft article. I don't know if it's that the article that you are asking. Is it the problem of translation? Is it? Are you asking about the relevance of the article?
So, is there any jurisprudence that establishes that a coup constitutes a violation of rights?
Et je vais traduire. Est-ce qu'il y a une jurisprudence qui a déjà établi qu'un coup d'État était une atteinte aux droits fondamentaux de l'homme, de l'être humain?
Nous avons dit devant votre cour, on en a.
We said before your court that we don't have it, but in the commission, in our elaboration above that, the commission highlighted that the coup d'etat can lead to violation of people's, notably their political rights. The African Commission for Human Rights and People's Rights in the Jawara, in the case of Jawara versus Gambia, it's been highlighted. Honorable Judge, we were demonstrating that the violations to privacy of to Mr. Ditan's privacy was violated, and here we are alluding to referring to Article 30 that your court would have had to do with this case because there was violation. And referring Article 15.
Hello, Council, have been mentioning number of, referring just article. Article of what? Article of the Charter, article of what? Because when you say Article 30 of what? You have to clearly, refer the piece of law which you want the court to consider.
L'article sur
Article 30 on the rights of people that determines political rights at Article 20, paragraph 1 of the African Charter for People's Rights and Human Rights and People's Rights. We was demonstrating that paragraph 15 of the factual report says that Mr. Ditan was arrested and convicted to 3 years in prison for having in violence for having shared messages that brought to public turmoil. So in the matter of Konate, Burkina Faso, we can say that Dita is a victim and of a violation of his liberty. And given the arguments of the applicants, we're asking your court that we declare you competent for all the material arguments, territorial, temporal, and declare that this application is admissible because it fulfills these conditions at Article 56 that refers to the Ouagadougou Protocol and to the internal regulations of your court. And we recognize that there should be reparation.
What is the test of proportionality?
Le principe de proportionnalité.
The proportionality principle is a principle that can assess the measures that have been taken against the rights of an individual. And this principle can be evaluated based on 3 requirements. First of all, the measure that was taken and the aim that is intended should enable to determine the proportionality and the limited rights, and research can determine the proportionality and the necessity of the measure in order to reach to the proportionality criteria.
So in this case, you're saying 3 years imprisonment is not proportional to what he did?
Vous dites que les 3 années de peine d'emprisonnement.
Are you saying the 3 years of imprisonment is not proportional? You have to.
Le juge demande si votre
judge is asking you, in your opinion, are the 3 years of imprisonment disproportional? Thank you, Honorable Judge. We are saying there is disproportionality because your court says that paragraph 66 that restriction to the right to liberty cannot lead to an imprisonment sentencing. So we're saying that this conviction was disproportionate.
Honorable juge, nous disons que
Honorable Judge, that we are asking you that, first of all, that the withdrawal done by Rwanda violates the Rwandanian rights, and Rwanda is responsible for the violation of the ONIA rights on their property, and there was a violation of children who were hired and working in hard conditions. The coup itself against the President Okello violates the Human Charter of the African Commission on Democracy and Governance. Finally, Mr. Ditan is a victim by violating his privacy and being restricted to his liberty of expression. Madam President is brought to your court, and it's like between the anvil and the hammer by the withdrawal of this country. That would reduce your praetorium to assessing whether the coup d'etat was a violation in this country. Honorable Judge, we're now at the end of this. We have got one compass. That's the preamble of the charter, in which states reaffirmed their abidance or their to conform to the rights of people's rights. And the victims we are representing are asking one question. On which side of the history would you position yourself in regard to these people? I want to end in French, if you allow.
Your Excellencies,
Are you asking the court?
Or in English, if you allow. He wants to end.
Yeah, because there was a question you posed before asking for the leave, to have few minutes to finish your submission. Then I asked, that question is posed towards the court, or you're posing that question to who? Or otherwise, there's a problem in interpretation. That's what we got.
pas une question comme c'était en anglais.
It was not a question. As I was, if you put on your headsets to follow the interpretation, please.
Your Excellencies, you are now at the crossroad. The preamble of the Banjul Charter as your compass, in which the states have clearly reaffirmed their commitment to freedom and human rights give trade you. You are facing history, and the victims we represent have only one question. On which side of history will you place yourself? Thank you.
Did you also learn English today?
Thank you.
No.
Thank you. The court will adjourn for 10 minutes before we come back and have the submission, our arguments from the respondents' side. So the court is adjourning for 10 minutes. After 10 minutes, the court will resume.